explain the position of UAE law with regards to the child relocation first, then we will go through the abduction scenario. As per the UAE law, the father would be considered the guardian and the mother would be considered the custodian till a certain age. The mother as a custodian doesn't have the right to relocate the child out of UAE without written consent of the father. Both guardian and the custodian have the right to put a travel ban on the child to block any potential chance of child relocation or child abduction. This right is stipulated in two articles of UAE law, article number 150 and 151. But the question which we would like to ask ourselves first, what will happen in case the father does not allow the mother to travel outside of the country with the child for a short-term period? In this case, the mother has the right to apply for short-term permission to travel through the urgent matter court. The decision would be issued within very short time, between 1 to 3 days normally. The mother has to provide guarantor to guarantee that she will be back after the end of the visitation time or the permission time. One of the most important questions which we receive sometimes, what will happen if the expatriate mother decided to leave the child in the UAE and for short term, for urgent and important needs for 2 or 3 days, and she would leave the child in very safe environment? Does this will affect on her ability to maintain the custody? Actually, this situation, we don't advise the mother to do it unless she has to do, because it gives the husband the right to raise question, and the matter will fall under the court discretionary power whether to maintain the custody with the mother for after this travel or not. But I would like to refer to one of the cases decided by Dubai courts, which case number 10 of 2008, which was decided 17 March 2009. In this case, the court indicated that the right of the mother to travel is constitutional right, and as far as she did not affect on the child's best interest, and as far as the court did not find that the child has been seriously affected, the mother shall remain the custodian even if she traveled and she left the child in UAE for a few days. So in general, it's not advised situation, but if the mother had to do it, still that doesn't mean that she would automatically lose the custody. When we would like to explain the child abduction cases, I would build two potential scenarios. First scenario, in case the mother abducted the child from UAE to somewhere else, and the other scenario in case one of the parents abducted the child from somewhere else to the UAE. I know that we have a challenge because we are not part of Hague Convention, so we have to depend on the applicable laws, which is the UAE criminal law, the UAE international cooperation judicial laws, and the civil law of Dubai, of UAE. In such scenario, the client would normally ask a few questions, which is very important to be covered before we decide on the best legal action to be taken. Does the court have the jurisdiction to decide in this case? Even if the child has been taken from UAE, still there is a potential chance that we can file a case in the UAE. And technically, that's what we do. First, the child might remain a UAE resident. The visa wouldn't be cancelled immediately. Secondly, if the child location and the respondent location is unknown, the jurisdiction shall be given to the UAE courts as per article number 6 of UAE personal status law. So we could build the jurisdiction in case of child abduction on base of last known location of the child and on base of the fact that the respondent location is unknown. Any one of them is a valid reason to build the jurisdiction solely. So as far as we agreed that we can take some legal action in the UAE, what are these legal action which we could take? First one, what we refer to Article 149, 150, 151, which indicated that the child shall not be relocated outside of UAE without both parents' consent. So if the custodian took the child out of the country, the father will have the right to file a custody case for abducting the child, and if the father abducted the child, the mother has the right to file a custody case to declare that she is the custodian. Why she need to file a custody case, although she is custodian by law, that's what we will explain later. After we agreed that we can get the custody court order to the mother, that wouldn't give her the child back. By the end, the client is searching for a strategic solution, not just a piece of paper to declare what's his rights. He knows his rights. So how we can get the child back? After getting the custody court order, and as per article number 328 and 329 of UAE criminal law, any party who has a custody court order has the right to file for parental child abduction case. In my presentation, I refer to the exact text of the article. As per article number 328, which is very important, the punishment for such abduction could be jail or fine. And that's very important. Because on base of such type of potential charges, the mother will have the right to apply for Interpol. The Interpol laws indicates that if any victim raised a criminal complaint and the potential sentence of the criminal complaint is jail not less than 1 year, then the victim would have the right to apply for an extradition notice or raid notice. Our laws say that it's detention or fine. It did not indicate how long is the detention, which means as per the general principle of law, the detention could be between 1 month to 3 years, which means that there is a potential chance of jail more than 1 year. And that gives the mother the right, or the father, or the victim of the case, the right to apply for parental Interpol raid notice for an extradition for the parental child abduction. As we indicated, after the criminal case is filed, and as per law number 59 of 2006 with regard to international judicial cooperation for criminal matters, and as per article number 7 of the same law, we have the right to apply for the Interpol. In my presentation, I refer to the exact text for easy reference for our colleagues. The other scenario which I get letter of instruction and request for legal opinion for is what will happen in case we have child abduction from other country to the UAE. Unfortunately, I have seen some fathers technically do abduct children to the UAE thinking that they will be staying in heaven where nobody will be able to trace the child or to get the child back. Fortunately, that's not true. Still, there are plenty of legal action, serious legal action, includes potential jail, could be taken against the father, regardless of convention application. We will assume in this scenario that if two expats living outside of the country, then one of them decided to abduct the child to the UAE, in such scenario could lead us to ask the following question. If the claimant got judgment from international court, will the UAE courts accept this judgment or not? Well, recognition of the foreign court order is organized in the UAE in article number 235 of UAE Civil Procedure Law. This article listed few requirements in any foreign judgment to be recognized. If one of them does not exist, the judgment will not be recognized. One of the most important factors in any foreign judgment that it has to be final, meaning that we'll have to provide certificate indicate that the judgment has not been upheld or appealed or amended by any other courts. Second factor, the respondent has to be given enough time to present his point of view, meaning he has been served notice in a proper way and given the chance to attend. Third factor, that the judgment shall not be decided on matter which the local courts have the jurisdiction to decide on it. And that's a very challengeable point. Because we agreed in the first two scenarios, local courts have jurisdiction to decide in both cases, whether the child was taken from UAE or the child was taken to the UAE. So because the local courts have jurisdiction to decide in the same case, and because it's highly expected and practical experience shows that anybody would bring the child to UAE will apply directly for local custody court order, we know in advance that the recognition of the foreign custody court order in the UAE wouldn't be acceptable in at least 90% of cases. So it shouldn't be the first scenario we should expect or the first strategy or plan to follow. At least to apply for recognition of the foreign court order. With regards to the treaties between UAE and other countries, after the morning discussion sessions, I brought the book which has all the treaties between you and all other countries in the civil procedure matter. And it's very obvious that in all the treaties signed between you and other countries, whether in India, China, Spain, France, there is a specific article which states what article number 235 is requiring. So the treaties here doesn't have big impact because what the treaty said is what exactly the law says. Even I found that in the treaty between Spain and UAE, it refers directly to the local laws applicable in Dubai or in the civil procedure law. Conclusion. In international child abduction from other country to the UAE, applying for recognition of the foreign custody court order might be a waste of time. The legal process could take 6 months to 1 year because there should be a proper notification process, a proper sessions to be given dates and given enough chance to respondent to submit his defense, and then giving him the right to appeal the case. It would take months. So we don't recommend to start by recognition of the custody court order as a first application. We might need it later, but not to get it in the recognition case. Local courts the right to build jurisdiction in both child abduction scenarios. That is the text of the article. So, as far as we agreed that we applying the foreign law, applying the foreign judgment in mirror order or in recognition case is not the best strategy. So what should be our strategy? We actually, the client would have many options to follow. First one, he would have the right to apply for a custody case. As we agreed that relocation of the child is a joint decision, none of the parents has the right to take this decision without the consent of the other one. So if it was done, the other parent will apply for full custody case in the UAE courts. And such custody case could be filed under UAE law or under the applicant law. One of the common cases, if we have a mother with a young child and the father brought him to UAE immediately without giving her any further notice or without keeping her prepared, the mother would be very emotionally stressed and wouldn't be able to afford to wait for long-term process till the dispute is settled. We have child interest at risk. We have the mother have been seriously harmed by the father act. We will be sure that we'll get her rights, but what about from now till she could get her rights? For this period, which could take months, what we can do? First action the mother could take is she can apply for urgent application to get the child back. Technically, we applied for this application many times, and always it works and it succeeds. Within 1 or 2 days, in case of child abduction to UAE, if the mother is ready to attend, we can go to the urgent matter judge, apply for immediate order to get the child, get the decision within 24 hours, go to the police, where the child is located, then we get the child back and we give him to his mother. All of this process is very fast, very easy, even it's not expensive. But we have to see what will happen next. The normal next step will happen, usually, that the father will immediately run to the court and apply for a travel ban. So we will get the child, but relocating the child could be another challenge. The mother still could file if she had the custody court order from the foreign court, and although we agreed that she cannot use this foreign court order in the local courts for recognition of foreign court order, still she might apply for child abduction case on basis of the custody court order she has. Because the criminal law did not require the custody court order to be from local courts or from foreign courts. It just states if one of the parents is having custody court order, he has the right to apply for child abduction. So the foreign child abduction could be used in the criminal court only, or could be used safely in the criminal court only. So first application we agreed is an urgent order to get the child back. Second application, she might file for a criminal case. Third application, she might file for a normal custody case, which would take normally at least 6 months. The mother would have another chance, which doesn't happen much, but we did it successfully before, where we could apply for temporary permission to keep custody of the mother. What is the difference between the first application and last application? The first one, we don't get custody, but we bring the child physically, but there is no technical term or definition to consider the mother custodian. But in the other one, the mother would be considered by definition as a temporary custodian till the dispute ends. That's the recognition of the foreign court order. As we indicated, it is a big challenge. Okay. I will just, in short, refer to two case study which we had. It's two interesting cases. We handled it, and it was published in most of the local newspaper in Dubai. First one was published in Al Khalij Times. where we had expatriate couple resident in the UAE along with their child, and there was an ongoing extradition case. Both of them were Russian, and the mother had extradition requests sent from Russia to send her back for a fraud case. Her passport was held in the UAE. Mrs. Awatif, my colleague, could attend in the case, and we could get the case dismissed. The extradition request dismissed because of time limitation. The case was 9 years back in Russia, and the UAE requires that any extradition request has to be for a case within the last 5 years. So the extradition request was dismissed, but when the father found that she is wanted in Russia, he took the child and ran away back to Russia, knowing that she cannot go back because she still have active case on the Russian legal system. So the wife couldn't run there, couldn't file any cases there. She doesn't have technically legal rights there. She had to file a case in the local courts in Dubai. 2017, she filed a custody case, and she won the custody case. Last week, this wife could get extradition request, the criminal case filed and the extradition request accepted, and this case was published today in some of the newspaper as a long story of what happened to this wife and how she could successfully, instead of being accused of extradition, now she is a claimant in extradition application against her husband, and she is requesting from the Russian government to bring the husband back. The other case study we had also was published in most of the newspaper here, where we had two Kazakhstani clients. Both of them were based in there. The mother was doctor, and she gave written consent to her husband to bring the child to the UAE for short term after they had divorce and custody dispute, and she have been awarded in Kazakhstan all her rights. And for the sake of maintaining good relationship with the father, she gave him written consent to come for a short period in the UAE. The permission was to bring the child for a short-term period, dated with start date and end date. The moment the father came to the UAE, he refused to return back, knowing that UAE is not part of Hague Convention. Because he is a father, he has the right to get residence visa for his child. He gives the child residence visa, didn't go back to Kazakhstan. Situation went smooth till his passport expired. Then, upon expiration of the passport, he had to file a family case against the wife. The wife knew that he is filing case here in Dubai, and then she came back, and we could get the child back with the same legal process. The links are in my presentation. It was published in Kharij Times, The National, and Gulf News.